Welcome to the Department of Economic Security, Division of Developmental Disabilities webinar on Article 9, Managing Inappropriate Behaviors, the History and the Future. We're going to start by talking about the differences between statutes, rules, policy, and training. The statute is the law made by the legislature and the licensing agency holding the responsibility under the statute, and they are responsible to develop the rules. Policies are developed as internal processes for the agency and do not have the force and effect of law. Training comes in at the end and is used as a mechanism to establish a uniform way to implement the statute, rules, and policy. It's important for us to discuss the history of Article 9. We're going to go back to the 1980s, and in the mid-1980s, Arizona was in the midst of deinstitutionalization with no standards for what this should look like. Planning had begun for Arizona to use Medicaid funding to support individuals with developmental disabilities, which included compliance with the regulations of the federal program. In 1988, the division drafted Article 9 in order to meet federal requirements. On February 20th, 1990, Article 9, Managing Inappropriate Behaviors, was adopted. At that time, there was no standardization or certification for training. There were designated DDD trainers from each district. They were given the copy of the Article 9 rules and a detailed explanation packet for them to complete the training. QVA trainers for group homes and DTAs developed their own curriculum and submitted it to DDD for approval. Article 9 was last amended effective August 30th, 1994. In 1996, training for Article 9 instructors was standardized. The qualified vendors sent instructors to the division for materials and trained the trainer class. In 1990, instructor training was extended and enhanced. Instructor survey of knowledge reveals discrepancies, and the statewide Article 9 work group was formed to develop the certification process. In 2000, the division removed prone restraints as an acceptable form of intervention from the crisis intervention training. In 2003, the Article 9 curriculum and participant guide was standardized. The Article 9 training, there was certification for providers and instructors, and the first qualified vendor-led instructors were trained and certified. We also had the first 6-hour Article 9 instructor certification clinics that were held by the division. In 2003 to 2005, the instructor clinics expanded from 6 to 8 hours and then again from 8 to 12 hours. We saw an increase for instructor clinics again in 2006, where the time was increased from 12 to 16. Also in 2006, the current application and screening process was developed, and a statewide instructor matrix was instituted to track all instructor certifications and recertifications. In July 2013, the seated basket weave restraint was eliminated as an approved technique. In 2016, DDD training offered 15 Article 9 instructor clinics across the state and certified 148 Article 9 instructors from qualified vendor agencies. We currently have approximately 600 certified instructors throughout the state of Arizona. The current version of Article 9 includes, but not limited to, limits on the use of certain behavioral intervention techniques, the responsibilities of the Program Review Committee. It outlines the roles of the services and program team. It identifies standards for monitoring treatment plans and the minimum requirements for training. It also speaks to the use of and requirements for medication. There are a lot of steps to revise rules, and the first step that the division must obtain is an approval from the governor's office, and that approval for Article 9 was obtained in 2016. Once we receive the approval from the governor's office, the division works with subject matter experts to develop a draft revision. That draft revision has to be approved by management team and access before it goes to our rules unit, who finalizes the draft for submission to our Attorney General's office and to the Secretary of State's for it to be posted for notice of proposed rulemaking, which includes public comment. The division reviews all comments and makes changes as appropriate, and then the draft goes back. The final version goes to for notice of final rulemaking with the Secretary of State, and then it is sent to the Governor's Regulatory Review Committee for a study session and approval. So we received a lot of questions on why the division is wanting to revise Article 9. And the main reasons why the division wants to revise Article 9 is that the current version of Article 9 does not include all requirements for the division programs. It doesn't reflect current evidence-based knowledge and professional standards, and the professional standards in the field, and it also hinders the development of appropriate behavior interventions for our members. We had a webinar on December 8th, and we shared our proposed revisions to Article 9. As a result of that webinar and the significant amount of comments that we received, the division took a step back and we started back from the beginning with a clean version of Article 9. We struck all of our revisions and wanted to share the considerations that the division was thinking about for revisions and wanted public comment from stakeholders. And the new Article 9 is to improve the standard of care for vulnerable populations and enhance existing safeguards by discouraging the use of punitive and outdated behavioral management risks, and to reduce the risk of any health and safety concerns for our members. Article 9 draft was posted on February 28th for a 30-day comment period. The draft includes each section and if there were revisions for each sections of the rules. There are 2 sections in the rules that we don't propose any changes to. That includes Section 901 applicability and 907 sanctions. We are considering adding a new section, and this would be the definitions. And we hope that this section would help in understanding the terms used within the article. And some of the examples of new terms include behavior assessment, functional analysis, and psychotropic medication. 902 is prohibitions. Some of the considerations include, but are not limited to, consolidating the prohibited behavioral intervention techniques, outlining the behavioral intervention techniques that a service provider can use only under the supervision of a licensed physician, licensed psychologist, or licensed board-certified behavior analyst as a component of an approved behavior plan. The techniques that those would need to be approved under are escape extortion, overcorrection, protective devices, forced compliance, response costs, and any other intervention techniques that may expose the member to conditions that are aversive or uncomfortable. The last consideration is add a provision to specify that any behavioral intervention technique used by a licensed professional while conducting a behavioral assessment or functional analysis shall use current evidence-based practices and does not require the Program Review Committee approval. 906 Program Review Committee section. We are considering adding a requirement that there must be a member from the Human Rights Committee participating in the PRC committee reviews. Section 904 is the ISPP team responsibilities. Considerations for this section includes the planning team being responsible to develop a behavior plan in collaboration with the behavioral health professional, and the planning team would be responsible for reviewing and monitoring the implementation and effectiveness of the behavior plan at each meeting. 906 is training. We're proposing to add language to clarify who is responsible for various training activities, including the responsibilities of the division and the author of the behavior plan. 908, emergency measures. Considerations include having additions in this section to allow providers to act in the least restrictive manner necessary to avoid serious injury or death, and add provisions to direct the trained direct support professional to intervene with the physical management techniques approved by the division if a member suddenly and unexpectedly displays behavior that poses a risk of injury to the member or others. Section 909 is behavior modifying medications. We're considering the removal of the provision for consulting psychiatrists reviewing cases and providing recommendations to prescribing physicians. Removing the division's responsibility to review behavior plans solely for the use of psychotropic medications. Removing provisions regarding an emergency situation. Removing the provision to notify the responsible person of any changes in medication type or dosage. Clarifying that only a licensed physician or other qualified behavioral health provider may prescribe psychotropic medication. And lastly, adding a provision directing a member to use psychotropic medication as directed and monitored by the prescribing physician or other qualified behavioral health provider. There will be general revisions to Article 9, such as rearranging and renumbering sections as appropriate. There could be some non-substantial changes to update or simplify language, and then we would incorporate revisions as appropriate based on the public comments that we receive, and we may include other revisions based on the public comment. Article 9 is currently open for feedback and comments, and those comments are due by March 30th. We have provided a link that you can access the policy page with the document of Article 9, and you may email dddpolicy@azdes.gov. And I just want to mention that this is only our first public comment period. Our final draft will be posted for a 60-day public comment period. Then we will respond to all of those comments. And then there will be a final 30-day public comment period. And we are looking for implementation in the next 9 to 12 months. Thank you.